Medieval canon law was the law of the church. Simple as that. It was the system of rules and principles that governed the Catholic Church and the lives of Christians throughout the Middle Ages. But it wasn't just for priests and monks. For centuries, it was one of the most important legal systems in Europe. It touched everyone's life, from kings to peasants. It decided who you could marry, what happened to your property when you died, and even what business practices were considered sinful. It was a massive, complex, and deeply influential body of law, but it didn't just appear out of nowhere. It grew slowly, piece by piece, over 1,000 years. Its roots are tangled and deep. The first and most important source was, of course, the Bible. Both the Old and New Testaments were seen as divine law. They weren't a law code. You couldn't just look up a statute. But they were full of moral commands and principles that formed the foundation for everything else. Jesus' words on marriage and divorce, for example, were the starting point for centuries of legal debate. After the Bible came the writings of the early church fathers. These were influential theologians like Augustine of Hippo and Jerome. Their opinions on doctrine and morality carried immense weight. When a difficult question arose, people would look to see what Augustine had said about it. His letters and sermons were treated almost like legal precedents. They weren't laws themselves, but they were powerful authorities that no one could ignore. Then, you had the councils. From the very beginning, when the church faced a major crisis or disagreement, bishops would gather to hash things out. The first big one was the Council of Nicaea in 325. These councils issued canons, which are just rules or decrees. A canon might say that a priest cannot be married, or it might define the proper way to celebrate Easter. These conciliar canons were some of the earliest and most universal forms of church law. They were decisions made by the collective leadership of the church. As the Bishop of Rome grew in power and prestige, another source of law became crucial, the papal decretal. A decretal was simply a letter from the Pope, usually in response to a specific question or a dispute sent to him for a ruling. A bishop in Spain might write to the Pope asking for guidance on a tricky marriage case. The Pope's written reply, his judgment, would then become a rule not just for that one case in Spain, but for the entire church. Over the centuries, popes issued thousands of these decretals. They became the case law of the church, addressing all sorts of practical, real-world problems. In the early Middle Ages, especially in places like Ireland and England, another interesting source appeared: the penitentials. These were little handbooks for priests. They were basically long lists of sins and the appropriate penance for each one. If a man does X, he must fast for 40 days. If a monk does Y, he must recite 100 psalms. They were very specific and practical. They weren't formal laws from a council or a pope, but they showed how the church was trying to regulate the moral and spiritual lives of ordinary people at a very local level. So, for hundreds of years, you had this jumble of sources. You had the Bible, the church fathers, canons from hundreds of different councils, thousands of papal letters, and local customs and penitentials. It was a mess. A bishop in France might be following one set of rules from an old local council, while a bishop in Italy was following a conflicting rule from a papal decretal. The texts were scattered across monasteries and cathedrals all over Europe. Many were forgeries. Many contradicted each other. There was no single, organized book of canon law. It was a rich tradition, but it was also chaotic and difficult to use. If you had a legal problem, you had to go on a treasure hunt for relevant texts, and then you had to figure out what to do when they didn't agree. This chaos couldn't last. The church was becoming more powerful and more organized. It needed a legal system that was just as powerful and organized, and that need set the stage for a revolution. The big change came in the 11th and 12th centuries. This was a time of huge upheaval and reform in the church. A movement often called the Gregorian Reform after Pope Gregory VII swept through Europe. The reformers had a bold vision. They wanted to free the church from the control of kings and emperors. They believed the Pope, as the successor of St. Peter, should be the ultimate authority over all of Christendom, in spiritual matters and even, when necessary, in worldly ones. This led to a massive power struggle with secular rulers, most famously the investiture controversy. The fight was over who had the right to appoint bishops and abbots. Was it the king or the Pope? To fight this battle, the popes needed more than armies. They needed arguments, they needed law. They needed to prove from scripture and tradition that they had the authority they claimed. This political need created an urgent demand for a clear, organized, and authoritative legal system. This is where a man named Gratian comes in. We don't know much about him. He was probably a monk who taught in the northern Italian city of Bologna around the year 1140. Bologna was just becoming the great center for legal studies in Europe. Lawyers were rediscovering Roman law, specifically the massive compilation of the Emperor Justinian, and they were developing new ways to study it, analyze it, and apply it. Gratian took on a monumental task. He decided to bring order to the chaos of canon law. He gathered thousands of texts from all the different sources, the Bible, the Church Fathers, conciliar canons, papal decretals, everything. He collected nearly 4,000 of them. But he didn't just collect them, he did something revolutionary. He organized them by subject, and, most importantly, he tried to make sense of them. His book was called the Concordia Discordantium Canonum, which means the Concordance of Discordant Canons. Today, we just call it the Decretum. The title tells you exactly what he was trying to do. He saw all the contradictions, the discordant canons, and he wanted to harmonize them, to find the concordance among them. He used a new method of study that was developing in Bologna, a method of questions and logical analysis. Here's how it worked. Gratian would present a legal question. Then he would line up all the authorities, all the texts that seemed to say yes. Then he would line up all the authorities that seemed to say no. He would put the conflicting texts side by side. It was a brilliant move. He didn't hide the contradictions, he highlighted them. Then, in his own commentary called Dicta, he would try to resolve the conflict. He would argue that one text applied to a specific situation while another applied to a different one. Or he would argue that one source was more authoritative than another, or he would use logic to show that the conflict wasn't as real as it seemed. The Decretum was a massive breakthrough. It wasn't an official law code. Gratian was just a teacher, not a pope. But his book was so useful, so comprehensive, and so intelligent that it immediately became the standard textbook for the study of canon law all across Europe. He had taken a messy pile of old rules and turned it into a logical, systematic, and rational subject. You could now study canon law in a university, just like you could study Roman law or theology. Gratian effectively created the academic discipline of canon law. An entire generation of scholars, known as the Decretists, dedicated their careers to studying and writing commentaries on his Decretum. They added to it, refined it, and argued about it. Later popes, like Gregory IX, would issue their own official collections of decretals to supplement and update Gratian's work. These collections, along with Gratian's Decretum, would eventually be compiled into a single great body of law known as the Corpus Juris Canonici, the body of canon law. This would remain the foundation of Catholic law until a new code was created in 1917. Gratian's work was the turning point. He provided the intellectual foundation that the newly powerful papacy needed. He created a legal system that was sophisticated enough to govern a vast international institution and to deal with the complexities of human life. After Gratian, canon law wasn't just a collection of old rules, it was a science. So we have the sophisticated body of law. How did it actually work in the real world? The answer is through a vast network of church courts. All across Europe, the church ran a parallel legal system that operated alongside the courts of kings and nobles. And for many types of problems, the church court was the only place you could go. This system had a clear hierarchy. At the bottom, you might have the court of an archdeacon, dealing with minor local issues like priests misbehaving or lay people failing to pay their tithes. Above, that was the most important local court, the bishop's court, often called the consistory court. This was the workhorse of the canonical legal system. It was here that most of the serious cases were heard, presided over by the bishop himself, or more often by his specially trained legal expert, the official. If you weren't happy with the decision in the bishop's court, you could appeal. The appeal would go up the chain, perhaps to the court of the archbishop. And at the very top of the pyramid was the papal court in Rome, the Curia. The Supreme Court of the Church was a tribunal called the Roman Rota. People from all over Christendom could, in theory, appeal their cases all the way to the Pope. This structure, a clear hierarchy of courts with a right of appeal to the top, was one of the great strengths of the system. It created a unified law for the whole church. What kinds of cases did these courts hear? Their jurisdiction was huge. First, they had authority over certain types of people. Any case involving a cleric, a monk, or a nun, even for a crime like theft or assault, was supposed to go to a church court. This was the famous benefit of clergy. They also handled cases involving widows, orphans, and crusaders who were considered to be under the special protection of the church. Second, they had authority over certain subjects, no matter who was involved. The biggest of these was marriage. The church considered marriage a sacrament, so everything to do with it was a matter for canon law. Was a marriage valid? Could it be annulled? Were a couple too closely related to marry? These were all questions for the church court. This gave the church immense power over family life, inheritance, and social structure. They also handled anything to do with last wills and testaments. The reasoning was that a person's final wishes were a matter for their soul, and therefore a spiritual concern. This gave the courts control over the distribution of property after death. They also dealt with oaths and contracts. Because an oath was sworn before God, breaking it was a sin, a spiritual offense. This pulled many commercial disputes into the church courts, and of course they had jurisdiction over purely religious offenses, heresy, blasphemy, sorcery, and sins like adultery or usury. The procedure used in these courts was also a major development. While secular courts in the early Middle Ages often relied on things like trial by ordeal or trial by combat, church courts used a system called Romano-canonical procedure. It was based on Roman law and was far more rational and modern. It was a written process. Everything was recorded: the initial complaint, the testimony of witnesses, the questions of the lawyers, the final judgment. The judge was an active investigator. He was expected to find the truth, not just act as a referee between two sides. Her decisions were based on evidence, on witness testimony and written documents. This procedural system was one of canon law's most important legacies. It was so effective that many secular courts began to adopt its methods. This system also created a new profession, the canon lawyer. To navigate this complex legal world, you needed an expert. Men flocked to universities like Bologna, Paris, and Oxford to study canon law. A law degree became a golden ticket to a powerful and lucrative career. Graduates could work as lawyers or proctors, representing clients in court. They could become judges in bishops' courts. They could become administrators and advisors to bishops, kings, and even the Pope himself. These university-trained lawyers formed a new international elite. They shared a common language, Latin, and a common legal culture that transcended local boundaries. They were the skilled bureaucrats who made the sophisticated institutions of both church and state run. They were the human machinery that put the great ideas of canon law into action. And canon law wasn't just an abstract system for lawyers and judges. Its rules and principles reached down and shaped the daily lives of everyone in medieval society. It defined the most basic human relationships, tried to impose a moral order on the economy, and policed the very boundaries of thought and belief. Nowhere was its influence more profound than in the law of marriage. Before the church took full control, marriage in Europe was a messy affair governed by local customs and family arrangements. Canon law changed all that. It developed a single, universal theory of marriage for all of Christendom. The canonists decided that the one essential element for a valid marriage was the free and willing consent of the man and the woman. This was a radical idea. It meant that, in theory, a couple could marry themselves simply by exchanging vows without the need for a priest, a ceremony, or even their parents' permission. This emphasis on consent elevated the individual's choice over the desires of the family or clan. Of course, it wasn't that simple. The church also created a complex set of rules about who couldn't get married. These were the impediments to marriage. The most famous were the rules of consanguinity and affinity. You couldn't marry anyone you were closely related to by blood consanguinity or by marriage affinity. And the church defined closely related very, very broadly, sometimes out to the 7th degree, or 3rd or 4th cousins. This had a huge impact on the landed aristocracy, for whom marriage was a tool for making alliances and consolidating property. These rules created a legal minefield, but they also created an opportunity. If a powerful lord wanted to get out of a politically inconvenient marriage, he might discover a long-lost cousin in his wife's family tree and seek an annulment. Canon law also taught that a valid, consummated marriage was a sacrament and was indissoluble. It could not be ended by divorce. The bond lasted until death. The only way out was an annulment, a declaration that no valid marriage had ever existed in the first place because of some impediment. For ordinary people, marriage was for life, a reality shaped and enforced by the local church court. The canonists also tried to regulate economic life according to Christian morality. Their most famous intervention was the prohibition of usury. Based on passages in the Bible, they taught that it was a sin to lend money at interest. Money, they argued, was sterile. It could not breed. To charge for its use was like charging for time, which belonged only to God. This prohibition put the church in direct conflict with the needs of a growing commercial economy. Merchants needed to borrow capital. Kings needed to finance wars. How could they do it without interest? In response, clever merchants and lawyers developed ways to get around the ban. Instead of a loan with interest, a merchant might enter a partnership where one partner provided the money and the other did the work, with the profits shared. Or a lender might sell something to a borrower on credit at an inflated price, effectively hiding the interest charge in the sale price. The debate over usury shows canon law trying to apply timeless moral principles to a changing, and often resistant, world. Perhaps the darkest and most powerful area of canon law was its treatment of belief itself. To the medieval mind, correct belief, or orthodoxy, was essential for salvation and for the stability of society. Incorrect belief, or heresy, was a deadly disease. It threatened the soul of the individual and the very fabric of the Christian community. And heresy was therefore not just a sin, it was a crime, the worst crime of all. Canon law developed a sophisticated legal procedure for dealing with heresy, the Inquisition. The term inquisitorial procedure simply meant that the judge was an active investigator, or inquisitor. It was his job to find the facts, to question the accused, and to get to the truth. When applied to heresy, this procedure gave immense power to the inquisitor. He could summon suspects, question them in secret, and use both spiritual and psychological pressure to obtain a confession. A confession was seen as essential, not just for a conviction, but for saving the soul of the heretic. To secure one, inquisitors were eventually authorized to use physical torture. Those who confessed and repented might be given a penance, like wearing a cross on their clothing or going on a pilgrimage. Those who refused to recant or who relapsed into heresy after repenting were relaxed to the secular arm. This was a legal fiction. The church claimed it did not shed blood, so it would hand the condemned heretic over to the local king or lord with the full expectation that he would be executed, usually by being burned at the stake. Through these laws and procedures, the church used its legal power to define the limits of acceptable thought and to enforce conformity with its doctrines. From the bedroom to the marketplace to the courtroom, canon law was a constant presence in medieval life. It wasn't just for popes, it was a force that actively shaped the world. The high point of medieval canon law was probably the 13th century. Popes like Innocent III acted like the supreme judges of Europe, and the Corpus Juris Canonici was a respected and powerful legal system. But things began to change. The power of the papacy was challenged, not just by reformers and heretics, but by increasingly powerful kings and nation-states. The Protestant Reformation in the 16th century was a massive blow. The reformers rejected the authority of the Pope and the entire legal structure that supported it. In England, King Henry VIII replaced papal authority with his own, and the English church courts gradually lost much of their power to the king's common law courts. Across Protestant Europe, the old system was dismantled. Secular governments took over jurisdiction of things like marriage and inheritance. The law became more national, less international. Even in Catholic countries, the rise of strong monarchies chipped away at the church's legal domain. Kings wanted to be the supreme legal authority in their own realms. The idea of a parallel legal system run by an international church seemed like a threat to their sovereignty. By the 18th and 19th centuries, the practical reach of canon law had shrunk dramatically. It was no longer the dominant legal force in Europe. So, is it just a historical curiosity? Not at all. The medieval canon law system left a long and deep legacy. It helped shape the world we live in today in ways most of us don't even realize. Its influence on the development of Western law is immense. Think about our idea of a trial. The Romano-canonical procedure used in church courts was, in many ways, the ancestor of modern continental European legal systems. The idea of a professional judge actively investigating a case, working from a written record, and seeking a rational conclusion based on evidence, this was a major departure from the older, more ritualistic forms of justice. It pushed Western law toward rationality and bureaucracy. The canonists also gave us the legal concept of the corporation. They needed to figure out the legal status of a monastery or a cathedral chapter. It wasn't a single person, but it needed to be able to own property, sign contracts, and sue or be sued in court. The canon lawyers developed the idea of a persona ficta, a fictional person. The group could act as a single legal entity, separate from the individual members who made it up at any given time. This is the direct ancestor of our modern law of corporations, from giant multinational companies to local nonprofits. Even in the English common law tradition, which prided itself on being distinct, the influence is there. The whole idea of equitiae, a system of justice based on fairness and conscience that exists alongside strict legal rules, has its roots in the canonical tradition, which always stressed that the goal of law was the salvation of souls, not just the rigid application of rules. For canon law also pioneered the idea of a systematic, university-based legal education and a professional class of lawyers. The model of studying a core text like Gratian's Decretum, writing commentaries on it, and training professionals who then go out to practice and administer the law is the foundation of legal education to this day. And of course, Canon law itself never went away. It simply retreated to govern the internal affairs of the Catholic Church. It is still a living legal system. The Church has its own courts, its own judges, and its own lawyers. They still deal with marriage annulments, the rights and obligations of clergy, and the administration of church property. The old Corpus Juris Canonici was finally replaced in 1917 with a modern systematic code of canon law, which was itself updated in 1983. It's one of the oldest continuously operating legal systems in the world. So while we no longer live in a world governed by church courts, the legacy of the medieval canonists is all around us. It's in the way our courts work, in the legal status of the companies we work for, and in the very idea of a rational, systematic body of law. It was a system built to govern a spiritual empire, but in the process, it gave the modern world some of its most basic legal tools. The long shadow of canon law is still with us.